Understanding the law is the first step to fighting back. Three major developments are reshaping the immigration landscape this March. Courts have blocked a controversial deportation practice, restored bond hearing access for thousands of detained immigrants, and a significant leadership change at the Department of Homeland Security is underway. Plus, the March 2026 Visa Bulletin brings real movement for people waiting on green cards. Let's start with the Visa Bulletin, because for many families, this is the most direct and immediate piece of good news in months. The U.S. Department of State released its March 2026 Visa Bulletin, and this month, USCIS confirmed that both family-based and employment-based applicants should use the dates for filing chart. This matters for you. The dates for filing chart allows people already living in the United States to submit their adjustment of status application earlier, before a visa number is actually available. In practical terms, this means you may be able to file paperwork now, begin building your record, and potentially secure work authorization while your green card case continues moving through the system. The movement this month is significant. Employment-based categories saw 45 advancements with no retrogressions. EB2 dates became current for most countries outside China, meaning workers with advanced degrees or exceptional ability from Mexico, the Philippines, and much of the world can file without waiting. EB2 India advanced 11 months. EB4 moved forward nearly 2 years across all countries. EB1 China and India advanced 4 months. If you or someone you love has a pending employment-based petition, check your priority date against the March Bulletin immediately. If your date is earlier than the cutoff listed for your category, you may be able to file your I-485 Adjustment of Status application right now. One important caution. The State Department noted that these advances are partly driven by a slowdown in visa issuance connected to current administration travel restrictions. If policies shift, retrogression is possible later in the fiscal year. This window may close. Act with your immigration attorney now if you qualify. Now to the court decisions, and these are significant. On February 25, 2026, U.S. District Judge Brian Murphy in Massachusetts ruled that the Trump administration's policy of deporting immigrants to third countries, places they have no ties to, is unlawful. This ruling struck down a Department of Homeland Security policy that had allowed immigration officers to remove detained people to countries like El Salvador, South Sudan, and others, sometimes with as little as 6 hours' notice and no chance to object. Judge Murphy was direct. People facing removal to a third country have the right to meaningful notice and a genuine opportunity to raise fears of persecution or torture before they are sent there. He wrote that the government cannot deport someone to the wrong country or to a country where they are likely to be persecuted without giving that person a chance to seek the protections the law provides. The judge paused his ruling for 15 days to allow an appeal, and the Department of Justice moved quickly, appealing to the First Circuit Court of Appeals on March 6th. The government argued the ruling would affect thousands of removals and disrupt diplomatic agreements with other countries. So here is where things stand. The ruling is currently on appeal. The First Circuit will decide whether to pause or uphold Judge Murphy's order while the case proceeds. And the administration has signaled it expects this fight to reach the Supreme Court, which has already intervened in this case twice before, ruling in the government's favor both times. For detained immigrants and their families, this means the situation is still in motion. The ruling provides protection in principle, but its enforcement depends on what the appellate courts do next. If you or a family member is in detention and facing possible removal to a country other than your own, contact an immigration attorney immediately. The legal landscape here is changing week to week. The second court ruling involves bond hearings, and it matters for tens of thousands of people currently held in immigration detention. Here's the background. Since July 2025, the Department of Homeland Security applied a policy that classified most people who entered the United States without being formally admitted as mandatory detainees. Under that interpretation, an immigration judge had no authority to consider bond, no matter how long the person had lived here, no matter their family ties, no matter their record. People were held without any individual review of whether detention actually served a purpose. On February 19, 2026, U.S. District Judge Sunshine Sykes in California vacated the Board of Immigration Appeals decision that had been used to justify that policy. Her ruling restored what had been the standard for nearly 30 years. If you entered without inspection and you are not otherwise required to be detained, you have the right to ask an immigration judge for a bond hearing. Judge Sykes was pointed in her language. She described the administration's conduct as reckless violations of the law and noted that it was not only the most serious cases caught in this dragnet, ordinary people, people with families, people with no criminal record, were being held without any individualized review. She wrote that Americans have expressed deep concern over what she called unlawful, wanton acts by the executive branch. A related February 18th order in the Maldonado Bautista case required the government to stop denying bond hearings nationwide and to notify people in writing of their rights, in both English and Spanish. But there is an important exception. If you are in immigration detention in Texas, Louisiana, or Mississippi, these rulings may not protect you. That is because the Fifth Circuit Court of Appeals ruled on February 6th that the government can lawfully deny bond hearings in those states. That ruling, issued in a 2-to-1 decision in a case involving the Texas, Louisiana, and Mississippi region, created a direct split with the rulings from California and Massachusetts. What does this mean in practice, right now? If you or a family member is detained anywhere in the United States outside of Texas, Louisiana, or Mississippi, you currently have the right to request a bond hearing before an immigration judge. The judge will evaluate whether you are a flight risk or a danger to the community. Factors that support a bond request include close family ties in the United States, a pending immigration petition, a clean criminal record, evidence of employment, community ties, and a demonstrated history of attending immigration hearings. An immigration judge granting bond does not mean your case is resolved. It means you may be able to pay a bond amount, typically ranging from $1,500 to $25,000, and continue your case from outside a detention facility while proceedings continue. If you are in Texas, Louisiana, or Mississippi, you are not entitled to a bond hearing under the Fifth Circuit's ruling. However, individual habeas corpus petitions, filed in federal court to challenge unlawful detention, may still be available to you. An immigration attorney familiar with the current legal landscape in your specific jurisdiction can advise you on your options. Do not sign voluntary departure documents without speaking to an attorney first. Once you sign, you waive your right to a bond hearing and potentially your right to apply for relief. This legal conflict between the Fifth Circuit and the other federal courts means this issue is almost certainly headed to the Supreme Court. The outcome will determine the detention rights of people across the entire country. Finally, the first major cabinet shakeup of President Trump's second term. On March 5, 2026, President Trump announced that Homeland Security Secretary Kristi Noem would leave her position effective March 31st. She will take on a new role as Special Envoy for the Shield of the Americas, a Western Hemisphere security initiative. Trump nominated Oklahoma Senator Markwayne Mullin to lead the Department of Homeland Security, pending Senate confirmation. Noem's departure came after 2 consecutive days of contentious congressional hearings in early March. Lawmakers from both parties questioned her about the administration's immigration enforcement operations in Minneapolis, where federal agents killed 2 U.S. citizens, Renee Good and Alex Preddy, in separate incidents. Noem drew bipartisan criticism after calling both victims domestic terrorists before any independent investigation had concluded, comments that conflicted with publicly available video evidence. She also faced scrutiny over a roughly $220 million border security advertising campaign that prominently featured her. When Noem testified that the president had approved the campaign, the White House denied it publicly. Senator John Kennedy described the president as not a happy cowboy after a private phone call following the hearing. A DHS Inspector General letter had separately accused her department of obstructing oversight work. Noem was the first cabinet secretary to depart Trump's second term. Across his first term, he went through 5 DHS secretaries. Markwayne Mullin, if confirmed, would be the first Native American to lead the Department of Homeland Security. He served a decade in the House before winning a 2022 Senate race in Oklahoma. His confirmation is expected to draw some bipartisan support, though the transition itself creates uncertainty during a period when DHS is managing extensive litigation, detention operations, and an ongoing government shutdown. So, what does all of this mean for immigrant families navigating the system right now? The courts are functioning as a check on executive immigration power, but that check is uneven and contested. Bond hearing rights exist in most of the country, but have been eliminated in the Fifth Circuit, which covers Texas, Louisiana, and Mississippi. That split is unresolved and headed toward higher courts. Third country deportations are currently blocked by a federal ruling, but that ruling is under appeal, and the Supreme Court has a history of siding with the administration on this specific question. The Visa Bulletin movement is real and time-sensitive. If you have an employment-based petition pending and your priority date is now current under the filing dates chart, this window may not stay open. Talk to an attorney about whether you can file your adjustment of status application in March. If you have a family member in detention, they may now have the right to a bond hearing they were previously denied. An attorney can help file a motion requesting that hearing based on the recent rulings. Time matters here. Legal landscapes shift, courts issue stays, and what is available today may not be available next week. Document everything you can. If you entered the United States on a visa or with any documentation, keep that paperwork somewhere safe and make sure family members know where to find it. If you were given any documents when you arrived or were released, preserve them. This information can be critical in a bond hearing or in defending against removal. Stay informed and know your rights. Record today, protect tomorrow.